introduced post-2024 to lower the standards of accountability. For a case involving 5.7 billion, can the Attorney General confirm that 1 billion has indeed been recovered and provide documented proof of the recovery? It is strange that the Attorney General is insisting that the amount of 800 million cedis recovered from Dr. Duffour constitute 60%. How did the Attorney General review the amount from the 5.7 billion to 1.2 billion by a mere administrative fiat? The best we heard from him today is to make arrangements for the amount to be paid into public fund. One would have thought that he would wait until the amount, the recovery that he's talking about, would have been paid into the coffers of the state before thinking of nolle prosequi. Did the Attorney General consider Section 35 of the Courts Act at 459 in coming out with the 60-40 threshold? For the avoidance of doubt, Section 35 of Act 459 states, and for the lack of time, let me paraphrase, that if you want to make any restitution in such cases, you consider Section 35, which says that a person may plead to a lesser amount, and then you can then enter a nolle prosequi or file anything for the courts to consider. And if the person fails to do that, then the person could be punished. When I finish, I can give you a copy of what I'm holding, and then you can have the full text of Section 35 of the Courts Act. Why did the Attorney General turn a blind eye on the above institutional provision? Why would the Attorney General also look at the principle of the plea bargaining agreement? Under our section, that is the Criminal Procedure Act, Act 30, as amended by Act 1079, and I have a copy of the Plea Bargaining Act as amended. The Attorney General is telling us today that he did not even look at the Plea Bargaining Act. He didn't look at the Courts Act. He didn't look at the Plea Bargaining Act. The process was not supervised by any court. But what he is telling us is that he himself, on his own, so motu, got the parties and negotiated with them. Where did he get the figures from? When the prosecution had already started this prosecution, and I have the facts as presented by the prosecution, and those who are interested, I can give you copies, you make copies of that. And when we had done this, why did the Attorney General ignore this, and why didn't he tell us anything from this? Why was the accused person not convicted, even when he agreed to pay 60% in line with plea bargain agreement under Section 35 or under the plea bargaining agreement or under Section 35 of the Courts Act? For plea bargain to be accepted by the court, there are a lot of options opened to the parties, including conviction. However, any such process must be supervised by the court. In the learned Attorney General's nolle prosequi, he just enters. Nobody would have thought that we would ask him questions. But because he chooses to say that he wants to be transparent, we want him to be more transparent and answer the questions that we are asking him. So how the Attorney General allowed the accused person to walk free without a conviction and without supervision of the process by the court? That definitely cannot be under a plea bargain agreement, as he had himself said. And if it is not a plea bargain agreement And it also doesn't come under Section 35 of the Courts Act. Where did he get the 60%, and how much has he collected? Today he tells us that he's going to make arrangements for the monies that have been collected, about 800,000, to be paid into government coffers. The learned Attorney General has obviously forgotten the theories of prosecution and punishment. In fact, if he had thought of it, he would have appreciated that deterrence is one of the theories that we take into consideration in punishing people. Ladies and gentlemen, as we conclude, we would like to take this opportunity to call on all voices of conscience in our society, especially lawyers, judges, civil society, clergy, traditional leaders, and you, the press, to sit down and watch, and not to sit down and watch on unconcerned, whilst the Attorney General, trusted with the office responsible to uphold the rule of law, on the contrary, pursue rather a destructive agenda to the detriment of the good people of Ghana. We therefore call upon any interested party, the Parliament of Ghana, particularly its Select Committee on Constitutional and Legal Affairs, to summon the Attorney General to answer these questions publicly. The Legal Counsel and Bar Association to investigate potential breaches of legal ethics and professional conduct. All patriotic Ghanaians to stand up against what appears to be the erosion of justice and the dangerous politicization of the prosecutorial process. Finally, may this press conference also serve as a formal notice to the Attorney General, Dr. Dominic Ayine, that if his decision is not reversed within a reasonable time, the minority will consider its options of proceeding to court to challenge its decision in its entirety. Let it be known that justice must not only be done, but it must be manifestly seen to be done.